This proposal revises current law to retain a no-fault system. It will still mandate coverage, but because it is required coverage, it does focus on providing essential services and care. The bill does, I would say, three kind of major things, or I'd like to talk about kind of three areas. It keeps in place many of the current procedures or provisions relating to the process. Now, it does have some new provisions, and I'll get to that in a moment. It retains many of the provisions in current law as it relates to the $10,000 limit, the benefit of lost wages, the benefit of funeral benefits. It doesn't change who was covered, but it does change what is covered. And it does that by focusing on what's called emergency care coverage, or ECC. Some of the salient points. First, and the way I've kind of have thought about this is to actually kind of refer to different sections of the bill. And so the first one would be Section 5, the definitions, and that's on line 285. But the point is that there are two main definitions that are added that will explain what's going to be provided under the coverage. And that is a definition of emergency medical condition, that's on line 289, and the definition of emergency services and care, which is on 305. And just to say as an aside, most of all the other definitions that are contained there are current law. And again, just kind of a way of explanation, you will see this bill it's all underlined. Well, the reason why we did that is because the bill really, as I say, replicates many provisions of current law. The old law will stay into effect for a period of time. I'll get to that in a second. So it's showing up all as new language. But I think it's fair to say, approximately 2/3 of it is just current law. And maybe we've made some cross-reference changes where we now talk about personal injury protection and it says emergency care coverage. But again, many of the provisions are the same as in current law. All that's showing up is underlined, which normally means new provisions. So the definitions of those two terms. Emergency services and care is the screening, examination, and evaluation to determine if one has an emergency medical condition. And if one does, then the care and treatment to alleviate or eliminate that emergency medical condition. So you really need to look at the definition of emergency services and care, and then there is a separate definition of what is an emergency medical condition. And so that really brings us to this new type of coverage, which is in Section 8, lines 531, the emergency care coverage benefit. Starts at the bottom of 531. Again, like current law, medical benefits, 80% of all reasonable expenses, but then spells out the new coverage. So briefly, let me go through that. Emergency transport and treatment rendered by an ambulance provider within 24 hours after the motor vehicle accident. And that would be, of course, similar in the sense of the type of service that's provided in current law. There's not a time frame under current law. There is here, but the service is basically what would be covered currently. Emergency services and care rendered within 72 hours after motor vehicle accident in a hospital license pursuant to Chapter 395. Okay, so obviously you have to look at the definition of emergency service and care, which I just mentioned. But that's what's going to be provided once they get to the hospital. Anyone, whether it's by ambulance or not, who presents themselves in the emergency room within that time period after a motor vehicle accident or an injury caused by that motor vehicle accident will be screened and evaluated to determine if they have a emergency medical condition. Okay, regardless of what they think the injury is, it will be screened and evaluated, and the insurer will be required to provide that coverage. And then there's services and care rendered when an insured is admitted to a hospital within 72 hours after the motor vehicle accident. Next, the next provision that you'll see on lines 542 are services and care rendered to an insured who's determined more than 72 hours after the motor vehicle accident to have an emergency medical condition. That it is envisioned one that's been determined in the hospital, but in any case, related to that initial diagnosis, which again was made in the hospital, and arising from the motor vehicle accident. The point there is trying to address a situation where when you present yourself to the hospital within 72 hours and you get that screening and there's a determination that you don't have an emergency medical condition, then subsequently it turns out that you might have an emergency medical condition, right? And so as long as it relates to that initial diagnosis and you went to the hospital with that period of time, then that care would be covered, okay, if it's determined you have an emergency medical condition. So it tries to cover that situation when it's subsequent to that initial 72 hours that you had symptoms, as long as it relates back to that initial diagnosis and it relates back to the motor vehicle accident. And then, if you've received care through any of those that I've just described, then you would get subsequent services and care, or just think of it as follow-up care. But that follow-up care is subject to the conditions that are delineated in the bill on lines 550 through 559. And that is that, again, if you're going to get follow-up care, it's got to relate to a diagnosis that was made in the hospital by a physician licensed under 458, a medical doctor or an osteopathic physician. And then that follow-up care, and that was the initial diagnosis, and then the follow-up care can be provided by those 5 medical professionals that are delineated: MD, DO, dentist, physician's assistant, and an advanced registered nurse practitioner. Now, right following that provision, and I think this is a key point too, to kind of recognize that determination of an emergency medical condition, again, it's going to be made by the physician in the hospital dealing with that patient. And we wouldn't want the situation, I think, where you have subsequent folks, insurers coming in and getting into a lot of dispute, right, about that issue of whether they had an emergency medical condition. They are allowed to question it, but I think in recognition that, you know, the important thing is that people get covered for an emergency medical condition, and that is something that the insurers will cover, is that the medical diagnosis that emergency medical condition exists is presumed to be correct unless rebutted by clear and convincing evidence to the contrary. So if there is a situation where it appears that wait, you know, this physician is really off base, an insurer could question it and overcome that presumption. But it does recognize that, you know, that the folks that are in the best position in most cases are going to be those that are right there providing that coverage. And that also, I think, provides some consumer protection for the purchase of this insurance. And so that's really, if you will, kind of, I think, the major components of the ECC coverage. I did want to address some other provisions in the bill, turning your attention to 722, line 722 rather. One of the issues that have come up in the hearings on this bill, and as y'all know, this was workshopped twice in the Insurance and Banking Subcommittee before the actual vote. So this issue was discussed at least 3 times this year as well as last year. The question about giving, you know, striking a balance between an insurance company having enough time to investigate a claim when they suspect fraud, or to try to have something to address that issue, and at the same time, you know, being careful that that wasn't being used as an excuse to delay payment for a valid claim. So the provisions on line 722 addresses that by saying that if an insurer has a reasonable belief that fraud has been committed, and they submit that claim for investigation to the Division of Insurance Fraud, then that claim filing period that they currently have to operate under, which is initially 30 days, that can be tolled until the Division of Insurance Fraud comes back and says, we find no basis for investigating further investigating this claim, or that there's no criminal action recommended, and then the insurer must pay it, and indeed would pay it with simple interest. Another issue that has come up in the past that the bill addresses is the issue about a fee schedule. And the new provisions, I think, really, the fee schedule is basically the same. It's been in the law, but there has been an issue about whether that fee schedule and the fact that there's a fee schedule, under the current law, can be used by the insurers. Is it in fact reasonable? And if they use that fee schedule, it would be reasonable to use it. The bill tries to address that point by in fact saying that in those instances, what some insurers told us happens, where if a health provider wants to charge less than the fee schedule, then they can go ahead, the insurer can go ahead and pay that, and that would be considered reasonable. But on lines 818, a payment made by an insurer that limits reimbursement to 80% of the following schedule of maximum charges is considered reasonable. And that would help clarify a current issue that has, quite frankly, been involved in a lot of litigation, and this will indicate that will be the case going forward. Another issue that's come up has been the issue of examination under oath, and that's addressed. But the new language, because we're modifying, there's a current provision in law dealing with discovery of facts about an insured person in disputes, but the new language really is found on page 41, lines 1121, and it does set forth provisions relating to examinations under oath. And basically what that allows, it does allow insurers to request, and indeed a provider would have to comply with examination under oath. There are provisions relating to the payment of a reasonable compensation, not just for the provider, but for anyone else that the insurer has indicated we need to talk to, another person in that office, or maybe another person that's been involved in the treatment. So compensation would be based upon good faith estimates of the hourly rate for a healthcare provider and the other persons to be examined, and the time required to conduct an examination. There's also a provision that says that an insurer, if as a general practice, requests examinations under oath without a reasonable basis, that they would be in violation or could be prosecuted under the Unfair Trade Practice Act. So it's trying to strike a balance. And indeed, I think, the other provisions I wanted to call your attention to, that's a new feature, and that's on the page 43, lines 1177, allowing insurers to conduct on-site physical reviews and examinations of maybe the treatment locations and the services that were provided, trying to address what has been an issue in the current system about providers that maybe did not have the type of services they were billing for. Moving on, I think the next key provision is on lines 1324, relates to attorney fees. This is a new provision, although for those that followed the debate last year, this was a provision that was in the PIP legislation last year that has passed out of the Civil Justice Committee last year. But in any case, it sets forth a schedule, if you will, of the attorney fees, and it's based upon the disputed amount and the amount that can be recovered by the attorney with certain limitations on that. There's also a provision that eliminates, and this is on lines 1346, 1348, that eliminates the use of the contingency risk multiplier for the new no-fault law that we've been talking about. And finally, in reference to attorney fees, there's a provision that limits the amount of attorney fees for class action proceedings. And finally, just a couple of final points. This is a new policy. There will need to be not only new forms approved, but new rates approved by OIR. And this does say, and this would be on lines 1660, that all forms and rates for policies issued or renewed on or after October 1st, 2012 must reflect the provisions of the Act and are approved by the office prior to their use. So they're obviously going to have to do their form filings and rate filings prior to October 1st. Now, it does bring up the issue of the effective date of the new law, and there's a couple of provisions that would go into effect earlier. And just on that point, the attorney fees provisions that I just talked about goes actually there's a section in the bill that replicates it. So that section dealing with attorney fees would go into effect upon the bill becoming law. Okay, but it's also picked up in the language that I mentioned to you before. It will continue in effect to occur after the bill goes into effect. But in any case, and there's another provision relating to the traffic reports that also will go into effect at an earlier date. But in any case, the law, these things that we've been talking about, the ECC coverage, they will apply to policies that are issued or renewed after October 1st, 2012. So, just to be clear, if you currently have PIP coverage, which we all are supposed to have, and if or someone purchases it prior to October 1st, or if they renew it, and the information we have from the insurers are that most insurers, not all, but most have 6-month policies, if you will. And so you could have a situation where someone renews their policy in September, and if they wanted to continue, they could have that policy for another 6 months past October 1st. But when they come up for renewal, since that's after October 1st, then the new law would apply to them.